One of the biggest things that we're seeing among our clients this year is reimbursement rates. Reimbursement rates have become, kind of the number one issue, and frankly, from a variety of different directions, right? There was the sunsetting of DIR fees and kind of what that has meant to pharmacy providers. There's also been changes in kind of the percentages that certain payers might have made up for different pharmacies, whether it be from just growth, whether it be from acquisition, or whether it be from certain big plans migrating from one PBM to another. And then we're also seeing other things that relate to reimbursement rates, but aren't necessarily one of those issues. Like, for example, the implementation of prescription discount card programs onto benefits. Essentially, GoodRx partnering with ESI or CVS or some of the other big PBMs, and basically bolting on that prescription discount card program to those plans. So it's been one of the issues that has had a lot of our clients reach out to us since January 1st, and we've kind of seen a lot of different pieces of information from dealing with the clients, from dealing with the PBMs, and even from, as Steve mentioned, from discovery and litigation arbitration.
I have heard that. I have heard some clients bring up the discount card issue. What is, what are you telling clients in regards to, or what can you say regarding those when clients are seeing that those discount cards are being applied and so forth? So what's the initial response to client concerns there?
Yeah, and I want to get Steve to chime in on something that he's seen with some of his clients in particular. Sure. But one of the big things that we advise clients to do is to make sure that you understand your contract, make sure you understand what you're signing up for, who it's with, what the PBM has rights to do. But then at the point of sale, make sure you're paying attention to that data. Make sure you're paying attention to the basis of reimbursement. There's a field that literally tells you how they're paying you. Make sure you're paying attention to things like reimbursement network ID that tell you essentially what contract is being used to put that price into place. That's kind of the first step. The first step is kind of really understanding some of that. And then from there's some legal strategies that we've explored with some of our clients to either push back, to either potentially reverse rebill, or potentially to leave a network altogether. Steve, maybe you want to talk about some of the specific experiences that we recently saw.
Yeah, so we've been seeing experiences where on some payers the terms and conditions in the contract make it so that the reimbursements are really variable. You could have the same payer, the same drug reimbursed at different rates at different times for different patients. So one, it makes it very difficult to ascertain what the reimbursement rate truly is. And what we've been telling our clients to do is really look closely at your contract. And we could help pharmacies do this. Look closely at the reimbursement terms. And one of the nuances we've been seeing in the beginning of the calendar year is a lot of providers saying they're not even paying us what our contract requires them to pay us. And so to determine the next steps from there, it's understanding which contract says, understanding the reimbursement rates, and looking at more than just one claim. I've been reviewing for some clients, for example, the first full month of the calendar year, looking at the specific reimbursement rates, the specific AWP, and capturing different data fields from the pharmacy software system to determine what contract is this going under. And like Jesse said with the discount card, there's specific NCPDP fields that will indicate, for example, is this going under the GoodRx discount card program, even when it looks like it's adjudicating through a particular PBM. There's a field that, if you look at it, actually says like GDX, GoodRx, and will tell you, oh, this actually isn't adjudicating under your PBM contract. It's being pushed through GoodRx, and that changes the scenario. We've also been reaching out to PBMs saying you're not paying us properly under the contract, and really identifying the specific claims to get that information. We've been doing it through legal counsel. So what's good is it's bypassing some of maybe the no-name email boxes that a lot of pharmacies deal with. and it's getting to legal counsel knowing, okay, we're getting an email from outside counsel. If we don't answer this email, if we kind of brush this off, this might create legal consequences for us down the line. And also leveraging applicable laws. There's, depending on if it's a commercial program, a state Medicaid program, a federal payer program like Medicare, there are different laws that could intersect and make requirements for specific reimbursement rates. Medicare Part D requires that reimbursement terms be quote unquote reasonable and relevant. There are some state laws that specifically say you can't pay a pharmacy below acquisition cost, or have a process for a pharmacy to appeal MAC reimbursement rates that are below acquisition cost. And understanding the intersection between your contract, the reimbursement rates, and the applicable laws give pharmacies a fair number of tools to challenge underwater reimbursement or other unreasonable reimbursement terms.